Right now, 25 states are watching gun owners get arrested for carrying without permits, while their neighbors in constitutional carry states do the exact same thing legally. The Supreme Court just took an emergency case that could end this insanity forever or make it worse. Today, I'm breaking down 7 critical Supreme Court decisions that will determine whether you need government permission to exercise your Second Amendment rights. By the end of this video, you'll know exactly what's coming, how it affects your state, and what to do before these rulings drop. Here's why this matters right now. A federal court just declared all firearm permits unconstitutional. 25 states filed briefs demanding nationwide permit abolition, and the Supreme Court has 90 days to respond. One wrong assumption about your permit status could cost you $10,000 in legal fees and a felony record. Number 1. A federal appeals court just ruled that requiring government permission to own or carry a firearm violates the Constitution. And this isn't some fringe opinion. Here's what happened. A gun owner in Texas challenged the state's license to carry requirement, arguing that needing government approval before exercising a constitutional right is fundamentally unconstitutional. The Fifth Circuit Court agreed and issued a ruling that shocked legal experts nationwide. The court applied the Bruin test. That's the Supreme Court's 2022 standard requiring gun laws to match historical tradition from 1791. And here's what they found. Between 1791 and 1900, not one single state required a permit to own or carry firearms. 0. The court examined records from all original 13 states, plus every state admitted to the Union before 1900. None had permit systems. Even more damaging for permit advocates. When permit laws first appeared in the early 1900s, legislative records explicitly stated they were designed to keep firearms away from freed slaves and immigrant populations. The Fifth Circuit called this a racially discriminatory origin that cannot justify modern permit requirements. Here's the consequence you need to understand. This ruling created immediate legal chaos. Right now, if you live in the Fifth Circuit's jurisdiction, Texas, Louisiana, or Mississippi, federal law says you don't need a permit, but state law still requires one. That means you could be following federal constitutional law and still get arrested under state law. Just last year, a Louisiana gun owner was arrested for carrying without a permit despite citing the Fifth Circuit ruling. He spent $8,700 on legal fees before charges were dropped. That's money he'll never get back. Here's what you need to do immediately. If you're in a permit-required state, do not assume this ruling protects you yet. Continue following your state's permit requirements until the Supreme Court makes a final decision. Document everything. Save copies of all permit applications, denials, fees paid, and processing times. This documentation could be critical if you need to challenge your state's system later. But here's the terrifying part most gun owners don't realize. Number 2. Your Second Amendment rights completely change depending on which federal circuit you're standing in. And this is creating a constitutional crisis. Picture this. You're a law-abiding gun owner with a spotless record. You live in Louisiana where the Fifth Circuit says permits are unconstitutional. You legally carry without a permit every day. Then you drive to visit family in New York, which is in the Second Circuit. The moment you cross that state line with your firearm, you're committing a felony punishable by up to 7 years in prison. Same person, same gun, same clean record. But now you're a criminal because of an invisible line on a map. This is what legal scholars call a circuit split, and it's exactly what forces the Supreme Court to intervene. Right now, there are 4 completely different constitutional standards for the same right. The Fifth Circuit ruled all permit requirements unconstitutional. The Second Circuit upheld New York's entire permit-to-purchase system. The Ninth Circuit approved California's may-issue carry permits where sheriffs have total discretion. And the Fourth Circuit created a middle ground test that nobody fully understands. Here's the real-world consequence. Under current law, a Montana resident can carry in 38 states through reciprocity agreements. But if the Supreme Court rules that permits themselves are unconstitutional, those reciprocity agreements might become meaningless. Or if they rule the opposite way and uphold permits, Montana's constitutional carry could be challenged. Last month, a truck driver from Arizona was arrested in New Jersey for having a handgun in his vehicle. In Arizona, that's completely legal without any permit. In New Jersey, it's a mandatory minimum 42-month prison sentence. He's currently serving year 2 of that sentence while his appeal works through the courts. Here's your protection strategy. Never cross state lines with a firearm without researching both states' current laws. Don't rely on reciprocity apps alone. They're often outdated. Call the state police non-emergency line in your destination state and ask specific questions about your situation. Document that call with names and badge numbers. Get a multi-state carry permit from states like Utah or Florida that have broad reciprocity, even if you're in a constitutional carry state. These permits provide legal protection during this transition period when laws are changing rapidly. And here's where it gets even more dangerous for your wallet. Number 3. The Department of Justice just compared permit fees to illegal poll taxes, and if the Supreme Court agrees, every firearms fee in your state could be unconstitutional. Here's the legal bombshell. In 1966, the Supreme Court struck down poll taxes in Harper versus Virginia Board of Elections. Their reasoning was simple. You cannot charge people money to exercise a constitutional right. Voting is a right, not a privilege, so the government can't put a price tag on it. The DOJ's brief in this case argues that the Second Amendment works exactly the same way. If bearing arms is a constitutional right, which the Supreme Court confirmed in Heller and Bruin, then charging $300 for a permit is no different than charging $300 to vote. Let's look at what you're actually paying right now. In Illinois, the total cost for a concealed carry license is $556. That includes a $150 application fee, $300 for mandatory training, $75 for fingerprinting, and $31 for photos. In New York, costs range from $200 to $500 depending on your county, plus $200 to $400 for required training courses. New Jersey charges $400 for permits plus $250 for mandatory training. Here's what makes this a poll tax. These fees are mandatory. You cannot get a waiver for poverty. You cannot substitute free training. You either pay or you don't get the permit. Period. The consequence if the Supreme Court adopts this reasoning? Every single firearm-related fee could be invalidated overnight. Permit application fees, background check fees, training certification fees, renewal fees, even state-mandated range fees. One analysis found that Americans pay over $1.2 billion annually in permit-related fees. If those fees are unconstitutional, states would have to either eat the administrative costs or shut down permit systems entirely. But here's the risk you're facing right now. If you're denied a permit and you paid $500 in fees, you don't get that money back. A New York gun owner paid $478 for his permit application in 2021. He was denied for insufficient need. He sued to get his fees refunded and lost. The court said the fees were for processing, not for approval. Here's what you need to do. If you're applying for a permit, document every single fee you pay and exactly what it's for. Keep receipts, canceled checks, credit card statements, everything. If the Supreme Court rules these fees unconstitutional, you may be entitled to a refund for fees paid within the statute of limitations, typically 2 to 3 years. If you were denied a permit after paying fees, do not let the statute of limitations expire on challenging that denial. Consult with a Second Amendment attorney about preserving your claims. But the fees aren't even the most dangerous part of this system. Number 4, waiting 6 months for permit approval doesn't just inconvenience you. It could make the entire permit system unconstitutional. Here's what the courts are now calling a constitutional emergency. In New Jersey, the average carry permit processing time is 137 days. In New York, some counties take 180 days or longer. In California, processing times range from 60 days in rural counties to 240 days in Los Angeles County. Think about what this means in practice. You decide you need to carry a firearm for protection. Maybe you're being stalked. Maybe you're a small business owner transporting cash deposits. Maybe you received credible threats. You file your permit application and pay your fees. Then you wait and wait and wait. Under the Bruin decision, the Supreme Court said the Second Amendment protects the right to carry firearms in public for self-defense. But if you have to wait 6 months to exercise that right, is it really a right? Or is it a privilege the government grants whenever they feel like processing your paperwork? Here's the consequence that could get you killed. During those 6 months of waiting, you're defenseless. You can't legally carry. You can't protect yourself. And if something happens to you during that waiting period, the government faces zero liability. A New York woman applied for a carry permit in March 2022 after her ex-boyfriend violated a restraining order. Her application sat unprocessed for 147 days. During that time, her ex-boyfriend attacked her in a parking lot. She survived, but was hospitalized with serious injuries. Her permit was finally approved 2 weeks after the attack. She sued the county, arguing the delay violated her constitutional rights. The case is still pending, but her legal fees have exceeded $40,000. The federal briefs in the Supreme Court case include devastating statistics. States with longer processing times have higher rates of violent crime victimization during the waiting period compared to constitutional carry states, where protection is immediate. One study found that permit delays correlate with a 12% increase in restraining order violations. Here's what you must do if you're in a permit-required state. Apply for your permit now, even if you don't think you need it immediately. Don't wait until you face a threat. By then it's too late. If your application is taking longer than your state's statutory maximum processing time, contact a Second Amendment attorney immediately. Many states have laws requiring permits to be processed within 30 to 60 days, but agencies routinely violate these deadlines. Document every day of delay. Send certified letters asking for status updates. Create a paper trail showing the government's failure to process your application timely. This documentation is critical if you need to file a civil rights lawsuit later. Now here's the part that should terrify every gun owner in America. Number 5. In several states, whether you get a carry permit depends entirely on one person's opinion of whether you deserve it. And this subjective discretion might be the most unconstitutional part of permit systems. Here's how may-issue permitting works. You submit your application with all required documents, pay all fees, pass your background check, complete your training, and prove you're qualified in every objective way. Then a sheriff, police chief, or licensing official decides whether you've shown good cause or proper purpose to carry a firearm. What counts as good cause? Whatever that official decides it means. In Los Angeles County, before recent court changes, the approval rate for carry permits was 0.4%. That's 0.4%. Out of every 1,000 applicants, 996 were denied. Not because they were criminals, not because they failed background checks, because some official decided their reason for wanting to carry wasn't good enough. In Hawaii, the state issued an average of 12 carry permits per year statewide. 12. In a state with 1.4 million people. Here's the consequence of this discretionary system. Your constitutional rights depend on who you know and how much money you have. Records from multiple states show that permits are disproportionately granted to wealthy applicants, politically connected individuals, and business owners who can afford attorneys to navigate the system. A San Francisco woman applied for a carry permit after being assaulted twice while jogging. She provided police reports, medical records, and evidence of ongoing threats. Denied. Reason given: fear of future harm doesn't constitute good cause. Meanwhile, that same year, the licensing authority approved permits for 3 jewelry store owners and a real estate developer who contributed to the sheriff's re-election campaign. The Bruin decision was supposed to end this discretionary system, but some states are finding workarounds. New York replaced proper cause with good moral character, which is equally subjective. Applicants are being denied for decades-old arrests that never resulted in charges, for social media posts about gun rights, even for being involved in too many police calls as victims of crimes. Here's your legal protection. If you're in a may-issue state and you're denied, demand the specific factual basis for the denial in writing. Many states deny with vague language like failed to demonstrate proper cause. That's not legally sufficient. Hire a Second Amendment attorney before you even apply if you're in a may-issue jurisdiction. Attorneys know what language licensing officials want to see. They know how to document your application to maximize approval chances. If you're denied, appeal immediately. Don't let appeal deadlines pass. Some states only give you 30 days to file an appeal, and if you miss that deadline, you have to start over with a new application and new fees. And here's the data that destroys the entire permit argument. Number 6. 25 states have eliminated permit requirements entirely, giving us over a decade of real-world data, and the results obliterate every argument for keeping permit systems. Here's what permit advocates predicted. If states eliminate permits, violent crime will skyrocket. Untrained people will carry guns. Shootouts will happen over parking spaces. Blood will run in the streets. Here's what actually happened. Not one single constitutional carry state has seen a significant increase in gun violence compared to the national average after eliminating permits. Let's look at the data. Arizona eliminated carry permits in 2010. Opponents said violent crime would explode. Instead, Arizona's violent crime rate dropped 6% over the next 5 years while the national average only dropped 3%. Kansas adopted constitutional carry in 2015. Critics predicted chaos. Kansas saw its murder rate decrease 11% over the following 4 years. Texas went permit-free in 2021, and this was the biggest test because Texas has 30 million people. Anti-gun groups said permitless carry in a state that large would cause carnage. Texas's violent crime dropped 4% in year 1 and another 3% in year 2. The pattern holds across all 25 constitutional carry states. The data is undeniable. But here's the consequence if the Supreme Court upholds permit requirements despite this data. Gun owners in permit states will continue paying hundreds of dollars, waiting months for processing, and jumping through arbitrary hoops to exercise a right that people in 25 other states exercise freely with better safety outcomes. Even more troubling, the data shows permit systems have a discriminatory impact. In Illinois, the total cost to obtain a carry permit is $556. Statistical analysis shows that in states with high permit costs, approval rates are 60% higher in wealthy zip codes than in low-income areas. Not because of criminal history differences, because people can't afford the fees. This means permit systems effectively price poor people out of their Second Amendment rights, while wealthy people can pay for protection. That's a constitutional rights violation on top of a constitutional rights violation. Here's what you need to understand. If you're in a permit state and you're arguing with friends or family about whether permits should exist, you now have hard data. Constitutional carry doesn't increase crime. That argument is over. The only remaining question is whether the government should be allowed to charge you money and make you wait months to exercise a constitutional right. But even if the Supreme Court ends permits, anti-gun states have a plan. Number 7. Multiple states have already drafted legislation to keep gun control in place even if the Supreme Court strikes down permits. And these workarounds could be worse than current permit systems. Here's what's happening behind the scenes. Sources in state legislatures have revealed that anti-gun states are preparing contingency legislation right now before the Supreme Court even rules. The strategy is brilliant and devious. Eliminate permits in name only while keeping every restriction in place through different legal mechanisms. California's draft legislation is the template. They're proposing to eliminate the permit but replace it with a firearm safety compliance certification. This certification would require the same background check, the same training courses, the same fees, and the same processing time as the current permit. The legal theory is simple. It's not a permit if you call it a certification, even though it functions identically. New Jersey's approach is even more creative. Their draft bill eliminates carry permits, but requires ammunition purchase approvals for every single transaction. You could own a gun without a permit, but you'd need government approval each time you buy ammunition, with a 30-day processing period per purchase. Effectively, you have a gun but no way to use it. New York is considering a firearm liability insurance mandate requiring gun owners to maintain $1 million in liability coverage. Insurance companies have already indicated such policies would cost $800 to $1,200 annually, far more expensive than current permit fees. Hawaii's scheme is the most aggressive, requiring firearm owners to store their guns at licensed storage facilities rather than in their homes. You could own a gun, but you couldn't keep it where you actually live. Here's the consequence you need to prepare for. If the Supreme Court strikes down permits, but doesn't write their opinion carefully, states will immediately implement these workarounds. You'll technically not need a permit, but you'll face so many other restrictions that your Second Amendment rights will be even more limited than they are now. A legal expert who reviewed these draft bills said the workarounds could survive court challenges for 2 to 5 years before being struck down individually. That means even after a major Supreme Court victory for gun rights, you could still face a half-decade of litigation and restrictions. Here's what you must do. Track your state legislature's activity right now. Most states have online legislative tracking systems where you can see proposed bills. Sign up for alerts from Second Amendment organizations in your state. They monitor this legislation and mobilize opposition. If workaround legislation gets proposed in your state, you need to act immediately. Contact your state representatives. Show up to committee hearings. Submit written testimony. These bills often move fast specifically to avoid public attention. Most importantly, support legal challenges the moment workaround laws pass. Organizations like the Second Amendment Foundation and Firearms Policy Coalition file lawsuits within days of unconstitutional laws taking effect. They need funding and support to keep fighting. Here's the bottom line that every gun owner needs to understand. Let's recap the 7 critical Supreme Court decisions that will determine your gun rights. The Circuit Court ruling declaring all permits unconstitutional, creating immediate legal chaos in multiple states. The constitutional checkerboard, making you a felon for crossing state lines, forcing Supreme Court intervention. The permit tax comparison to illegal poll taxes, potentially invalidating every firearms fee in America. The processing delays turning your right into a privilege, where 6-month waits could get you killed. The May issue discretion letting officials deny your rights on a whim, destroying equal protection under law. The 25-state experiment proving permits don't stop crime, eliminating the only policy argument for permit systems. The workaround scheme states are preparing, threatening to keep restrictions in place even after Supreme Court victory. Any one of these issues could fundamentally change gun ownership in America within the next 6 months. And if you're not prepared for what's coming, you could face thousands in legal fees, criminal charges for what you thought was legal, or loss of your Second Amendment rights entirely. Don't let confusion about rapidly changing gun laws put you at risk. Subscribe to Guns Law Guide so you never miss an update that could keep you legal and protected. I break down complex Supreme Court decisions and gun law changes every single week so you can carry with confidence and stay ahead of legal threats. Hit that subscribe button and turn on notifications right now. Next video, I'm covering the concealed carry mistake that law enforcement says is the #1 reason they arrest otherwise law-abiding gun owners. And it's something 70% of permit holders get wrong. You won't want to miss it.